Free kill is the name of a Florida law that few know about until a loved one dies of medical malpractice. The law prevents adult children or the parents of adult children from suing for damages in a wrongful death case. But there's pressure building to abolish the law. I'm joined today by two people who followed the issue closely. Sabrina Davis lost her father 3 years ago in what the Florida Department of Health determined was medical malpractice. Sabrina, thanks for being here, and we're so sorry for your loss.
Thank you so much for having me today.
We're also joined by anchor and First Coast News reporter Heather Crawford, who has done several stories on this unusual Florida law and joins us by video link. Good morning, Heather.
Good morning, Ann. Thanks for having me.
Thanks so much for being here. And to our listeners, have you had to deal with Florida's free kill law? Do you have questions or concerns about it? Give us a call at 549-2937. Email us at firstcoastconnect@wjct.org. You can also message us on Facebook or Instagram or tag us on X at FCC On Air. Sabrina, start us off, if you would. Tell us a little bit about your dad, Keith Davis.
Sure. My dad is a 62-year-old, self-sufficient veteran of the United States Navy. He lived just outside of Tampa, Florida, and he was just so full of life. He loved to play the acoustic guitar, work on old cars, had a great group of friends, and never met a stranger. My dad was really an amazing person with so many powerful stories from his time in the Navy and being in the submarine. And that's my dad was just my voice of reason. He was an amazing person.
And tell us what happened in October 2020.
So in October of 2020, my dad woke up and he had knee pain and he was not able to walk. So he contacted me and we decided that he needed to go to the ER, which was not like him. He did not ask for help. So the fact that he agreed, I knew it was bad, like he really needed to go. So we got my father to HCA Brandon Hospital and he arrived with swelling, redness, pain, unable to walk. His left leg was even hot to the touch. He had all of the textbook classic signs and symptoms of a blood clot. He also had a history of blood clots, and he was taking a blood thinner. So upon documentation of his signs and symptoms and his past medical history, we asked several times for hospital staff to please order an ultrasound to check for a blood clot. My dad even stated that his left leg was feeling like his right leg did in 2008 when he had a 10-inch long blood clot at the very same hospital. And hospital staff said no, they didn't need to do an ultrasound and that my dad needed bed rest and physical therapy. So the next few days, my dad received inpatient physical therapy at the hospital, and he was not making any progress. He was not doing any better. We spoke every day. He sent me text messages, videos. He even states in one of his videos that he's unable to point his toes straight up, which is a classic sign of a blood clot. So despite our ongoing pleas for an ultrasound, we were still ignored. And on Thursday, October 15th, my dad and I spoke that morning, and he was fine other than the pain. His doctor came in and said, "I'm discharging you today for physical therapy." And we were so happy that we were making plans. I was going to bring him some stuff up to the physical therapy place he was going, and we had a great conversation. So 19 minutes after we spoke, I received a call from the hospital, and they said, "Your dad is code blue. He has no pulse and he's not breathing. What do you want us to do?" And I said, "You have to have the wrong patient. My dad's fine. Like, he's being discharged today. This cannot be my dad. We just spoke." And they said, "No, it is your dad. What do you want us to do?" And I said, "Well, you get him back and you don't stop till you do, but I don't think you have the right patient." Well, it was my dad, and no form of resuscitation helped. So at this point, my dad was dead.
Terrible story. Heather Crawford, you have reported on the issue of Florida's free kill law. And I think you found that Sabrina's story, sadly, is not unique. When did you start reporting on free kill, and how did you first learn about it?
Yeah, it was this past fall, Anne, and it came with an email to our newsroom, and it was from a St. Johns County mom, Cindy Jenkins, and she said, "My daughter is a Florida free kill," and that headline, that word is jolting. What do you mean a free kill? I've been a journalist here for more than a decade. I've never heard of this law, and you're right. As we started investigating, as we started reporting, family after family after family came forward to say, "It happened to my loved one too." And it happened to my loved one too. And there's nothing you can do. And I think that's so gut wrenching that anyone can relate to that. You lose a loved one to what you believe is medical malpractice. It can be as egregious as a doctor cutting off the wrong leg and your loved one dies, and you go and start calling attorneys and you can't even find out. You don't even get your chance at your day in court because under Florida law, you can't take it to the court. And so attorneys told me, yeah, it's the number one reason we deny taking on medical malpractice claims, because in Florida, if you are over the age of 25, you are not married, whether you're widowed, divorced, or never married, and you have no children under the age of 25, then you cannot file a medical malpractice lawsuit against the doctors, against the healthcare facility. You are basically shut out of court. And I think that's a second level of grief that these families have to go through. And, it doesn't matter whether you live here in the state of Florida. We have a lot of tourists who come. We have a lot of folks who come down just for the winter. If this happens in a Florida hospital, your family can't do anything.
And I think what is so shocking is it's not widely known, right? So people are encountering this when they're grieving their
Mhm.
loved one or the loss of their loved one, only to learn about this sort of obscure law. It has been getting more attention, though. Is that right? And largely due to people like Sabrina.
Right. So it's been on the books since 1990. And for several years now, folks have been fighting to get this law outright repealed. And it has never garnered enough support in the Senate to be able to be repealed in full. Well, after I interviewed Cindy, I met Sabrina and Cindy and so many families are on a mission. They are on a mission to get the law changed, whether it takes a small step at first or a full right outright repeal, which they all want. They want action. They want change. And I feel like the climate, the level of attention this is now getting because of so many families sharing their story and speaking out, I feel like it's finally getting lawmakers' attention to say, wait, why does Florida have this on the books? Is it needed? And what can we do to help families? And some of the lawmakers who are fighting to change it themselves are considered free kills, not married, no children under the age of 25. And they know that if they go to the hospital and they die of medical malpractice, nobody can bring a lawsuit.
So, Sabrina, you drove a couple hours to get here this morning. You have been doing a lot of traveling and a lot of advocacy around the state. This really has taken over your life in a lot of ways.
It has. It really has. It's obviously a fight that I never wanted to be a part of. I work in the medical field myself, and I was not aware of this law. And it's scary to think that I could go to work and mess up, and if the patient is single with no child under 25, I would get away with it. And that's not the way it should be. That is not part of the oath that healthcare professionals take. And as human beings, we are taught accountability at such a young age. And in my opinion, we should not ever divert from that, especially when it comes to something like the standard of care when people are caring for other human beings. Why would some lives matter less just because they are single with no minor kids? Another population that this widely affects is people with disabilities such as autism or Down syndrome who have little to no chance of ever getting married or having children. They are automatically in this category at 25. And it's been on the books since 1990, like you guys mentioned. The reason this law was created was to decrease medical malpractice premium rates and prevent doctors from leaving Florida. Well, the opposition still argues to this day that Florida has some of the highest med mal premium rates. So I'm here to say that this very outdated law created 33 years ago did not do or accomplish its intended goal and has instead created a cascade of unintended consequences for families like myself. And I think it's time we address it.
Now, you talk about people who oppose repealing the free kill law. We reached out to attorney Andrew Bolin and asked him to join our conversation today. He's a trial attorney who represents the healthcare industry, and he's lobbied on behalf of the Florida Justice Reform Institute to keep the free kill law intact. He joins us now. Good morning, Mr. Bolin. Thanks for giving us a call. Can you explain why you oppose getting rid of this law?
Sure. So let me start by addressing the verbiage we're using when we talk about free kill. I think that's a disservice to our medical community, first and foremost, because we have physicians and healthcare providers, just like the guest that you had was just talking a moment ago, who dedicates their entire lives to helping people, treating people, and making them better. And there isn't a single piece of anecdotal evidence to suggest that any medical decisions are ever being made based on whether or not someone has survivors for a medical malpractice action. So on behalf of my clients, I just think I need to start by saying that. Secondly, let me say that the issue that we have is not one of individual cases. Those are heartbreaking. We can certainly empathize with the situations that any one of them face. But here's the reality, is that anytime we're dealing with the law, the Florida legislature is going to have to make a decision as to where to draw the line. And in this case, facing a pending and looming medical malpractice crisis in the state of Florida, they chose to draw the line where it is today, where the Wrongful Death Act makes it. And we have, if you look at not only the number of medical malpractice cases that are being filed, but also the severity of cases in the state of Florida, meaning the amount of money that it takes to settle the case or the amount of money that juries are awarding in cases, this is not the time to remove protections from Florida's healthcare industry. We have 50% increase in doctors reporting that they're going to leave the state while we have booming population increases. So it certainly can seem unfair when we're looking at any individual anecdotal case, but the law doesn't operate that way. The law operates by looking at the industry as well as the situation as a whole, and it makes determinations as to how to best balance the interests of both sides of the equation.
But I think,
I think that's what you've seen the legislature do.
Yeah, I just want to ask, kind of to Sabrina's point, though, and I don't think you've challenged this. I mean, the cost of medical malpractice has continued to rise since 1990. Insurance costs for doctors in Florida are among the highest in the nation. Is there any evidence that this law that's colloquially known as free kill has done anything to reduce the costs to physicians?
Sure, I think that is a very good point, and here's the issue with that, is that anytime the state of Florida passes reforms, there's great uncertainty as to whether or not they're going to last, and so the wrongful death statute being presented as it was, it was part of a broader package of medical malpractice reform. And over the years, there's been other steps to try to curb the tide of medical malpractice premium increases and doctors leaving the state of Florida. Unfortunately, what happens is that those tort reforms are repealed or they are deemed unconstitutional by the courts so quickly after they have been put into place that it doesn't give the industry time to catch up. And so I agree with you that the reforms that have been put in place and then taken away, we haven't seen the impact of them the way that we hoped that it would. But that isn't a reason to then remove more reform and more protections for physicians. That's only going to exacerbate the problem.
Thanks, Andrew Bolin. Heather Crawford, I want to ask you about that. This bill is sort of surgical in its approach. It really is looking at just that one element of a lot of medical malpractice, tort reform type laws, and wants to take out that one single element that is called free kill. But there are a few competing bills out there right now.
Right. So there are 5 bills right now, some introduced in the House, some introduced in the Senate. Some of them would outright repeal what this caveat to the wrongful death lawsuit. Some of them, Clay Yarborough introduced a bill in the Senate that would add a caveat. It would say these two categories of families could sue if the Florida Department of Health or Healthcare Administration first determined that there was probable cause. Now, when you ask families impacted by this law what they think of that, they're divided. Some say, yes, let's just take any step to get this closer to being repealed. Other families say, no, that would even be harder, because the problem is right now, a lot of people who want to keep the law in place say, well, there is a way to hold. We have many, many wonderful, incredible doctors in the state of Florida. But for ones that are committing malpractice, that maybe do need to have something in place to make sure it does not continue to happen, to discourage bad actors, if you will. This law isn't. There's nothing there to hold them accountable, and supporters of the law may say, well, you could file a claim with the state. And so Sabrina filed a claim with the state, and the state said, yes, we found probable cause of medical negligence. And Sabrina did not receive any money, but the doctor was fined, and he was fined $7,500. That's what the fine was. And so getting even through that process of going to the Department of Health and Healthcare Administration is a tedious, long process that can take a very, very long time. And families described it as like you're having to climb Mount Everest just to get that ruling. So it can be very hard and very grueling. So I feel like there's going to be some sort of consensus. Right now, none of these bills that are before the legislature mention any caps, but I feel like that's something that some families may support, is to have some sort of, okay, these two categories of families could support this law, or a repeal of the law, and maybe there's some cap so it's not outrageous lawsuits being filed. All of the families I talk to say, hey, it's not about money. In fact, many of them have already passed the time limit where they could bring a lawsuit, so they're doing this for future families. And they say it's not about the money, it's about making sure something like this does not happen again to someone else's loved one.
Sabrina, talk about what your motivation is in this case, and to what Heather brought up, the amount of the fine that the doctor received in the case involving your father.
Sure. I first want to just say, as far as Mr. Bolin mentioned, I 100% agree with him that healthcare professionals, they don't go to work looking to see who falls into this category. I removed the term free kill from my vocabulary a long time ago because I'm glad to say that that's something I can agree with him on. That is one thing I can agree with him on. Unfortunately, that's what it's been known as, so that's what people call it. I think of it more as legalized negligence rather than free kill. As far as the fine, I think it was a slap on the wrist. There's no motivation for the doctor that did this to my father to do better. I could have paid the $7,500 fine for him several times. And that was a very low ball fine that, in my opinion, didn't teach him to pay more attention and to do better when it comes to his patients. He's 79 years old. He's been practicing 40 years. And one may think, wow, he must be so smart. I would agree. I think he's very smart. I think he made a conscious disregard for my father's life. In 40 years of practicing medicine, a person has done roughly 200 hours of CEUs, continuing education unit classes. And there's not a doubt in my mind that says this doctor wasn't smart. He just failed to do his job on this day, and it resulted in my father's death. And nothing will bring my dad back. No amount of money, nothing, no fine. But in my opinion, the least that I could do is to face this person in a court setting with a jury per the Constitution, where we all should be able to have equal access to the courts for redress. And right now I don't have that. My dad fought for the freedom of this country, and I feel like my freedom has been taken away.
We have a call. Chris in Clearwater has a comment about organ donation. Good morning, Chris, and welcome to First Coast Connect.
Good morning. I was wondering if this might be a factor as well for malpractice. I've come across at Life Guardian Foundation. Dr. Paul Byrne recommends folks might want to consider writing and documenting a refusal of organ donation because there have been so many cases where folks have been incorrectly declared brain dead and even made a complete recovery. He says that it's not good enough that you say at the DMV when you're getting your license or your ID that you don't want to be an organ donor. They can only harvest organs from living people. They can't store them. And there's one case I remember I just found again from 2015. George Pickering was actually in an armed standoff in Texas and saved his son, who had been declared brain dead. He stopped the medical staff with firearms to stop them from harvesting his son's organs. And also, if folks want to learn more, I actually have a blog on this over at the blogs page at theliberationstation.com.
Chris, thank you so much for your call. I appreciate it. I'm going to pick up with Mr. Boland again. Sorry, I think I disconnected from you there for a moment. But there's an understanding that medical malpractice somehow curbs behavior of physicians or corrects it. Can you comment to that at all?
Yeah, candidly, I don't know that there's any studies that have ever been done or published on how physicians or hospitals change practices as a result of singular lawsuits. I know that it certainly happens, but I don't know how widespread it is. I think the punitive nature of civil litigation in the state of Florida, unfortunately, may have an adverse effect on transparency and coming forward to make sure that systems are changed. I know, for example, many of the hospitals and the physician groups that I represent, they spend hours on quality assurance and peer review and root cause analysis whenever there's an incident that's done. And unfortunately, sometimes we have physicians and healthcare providers that are reluctant to participate in those things, not the subject of the malpractice, but witnesses, because of the fear of how that information is ultimately going to be used in litigation. So I think certainly that it can help curb some of the procedure and process problems that are out there, but it can also have an adverse effect as well.
Heather Crawford, there are, as you said, competing bills out there. From what I can tell, none of them are Jacksonville sponsors or sponsors on the First Coast, but you have talked to local lawmakers about this. What is their interest in this? What's their appetite for bringing some sort of legislation or sponsoring it here?
So there is one. Senate Bill 248 is Clay Yarborough's bill, and that is the one that I was talking about that would carve out for these two groups of people. They would be able to proceed to the court if they first find probable cause, if the state finds probable cause. So Clay Yarborough's been very interested. I do want to point out that of the 5 bills that have been introduced, this is not a Democrat or a Republican issue. It has bipartisan support. There are Republicans and there are Democrats who have introduced legislation to repeal or partially repeal this law. Clay Yarborough, when he was in the House, had voted to repeal the law. It did not make it through to the Senate. Now that he is in the Senate, he's working, trying to find a compromise. And I think when you talk to Sabrina, when you talk to a lot of these families, some of them are open to a compromise of taking a step. And so I think Clay Yarborough, Senator Clay Yarborough, who represents parts of the First Coast, has been working to find some sort of compromise to partially repeal this law. Now, not all families, some families are adamantly opposed to the partial. They want the full repeal. But there is a lot of interest, and Senator Yarborough is one of our First Coast lawmakers who's working to change it.
Sabrina, I think your case is different. Before the program, you were telling me that there are a number of people who oppose this law and want to repeal it, but not very many whose cases have been verified as medical malpractice by an independent determination.
You are correct. And for those reasons, I don't know why other cases haven't been found with probable cause or such. In mine, it was determined that the doctor worked below the standard of care and committed medical malpractice. Another aspect to this law that I find very difficult to understand why some think it's okay is that, in order to file a complaint with the Florida Department of Health, you have to be the administrator of an estate. My father died without a will. So first I had to go through probate. And within a week of my dad's estate being opened, when I pursued that avenue to become an administrator of an estate, the very first person to file a medical bill on my dad's estate was the very hospital that killed him for services they never did. So when I went to an attorney to try to fight these claims on my dad's estate, they said, oh, due to Florida Statute 768.21, subsection 8, we can't help you. Your dad was single and you're over the age of 24. Your dad is in this category. So, it also, outside of non-economic damages, economic damages, all of those things, it creates a very limited window of opportunity for people like myself to even have help to fight things that they should legally not be able to do. Why should we think it's okay for this facility to collect more money from my dad's estate after he has died due to their medical malpractice? It's wrong. And, Senate Bill 248 addresses that, and I strongly think it is because they've heard me speak on it, and I'm honored to have Rep. Lopez and Rep. Beltran be on board. And, one example that Representative Spencer Roach uses very often, and it's really stuck in my head, and I want to say it because it gives people a different outlook that you may not have thought of before, is so say a medical professional takes their lunch break and goes to have lunch and they have a few martinis, and say on their way back to work they run a stop sign and they kill your 26-year-old child. You are able to take them to court for economic and non-economic damages. But say somehow, after they had those martinis, they make it through that stop sign and get back to the hospital and operate on your son or daughter who is 26 years old, and they mess up killing them, and it's determined to be medical malpractice, and you have no right to have civil access to the court. Ask yourself, is that the way the law should work in Florida? I don't think it is.
What are you asking people to do to get involved between now and the legislative session next year?
Sure. So right now we are hoping to have the bills added to the agenda. House Bill 129 by Representative Lopez and Representative Beltran will hopefully be added to the agenda very soon. And the person in charge of allowing that bill to be heard is Representative Will Robinson in South Florida. And I would like to ask if everyone can reach out to him and ask him, please add House Bill 129 to the agenda. His email is will.robinson@myfloridahouse.gov, or his phone number is 941-744-5097. And that's what we're asking, for him to add this House bill to the agenda. And, for anyone that does do that, I can't emphasize enough to always be respectful when you contact lawmakers. They are lawmakers. They did not make this law, but they can help us change it. So with that being said, always have that respect.
Sabrina Davis, thanks so much for being here. Heather Crawford from First Coast News, Andrew Boland, appreciate all of you for being a part of the program today.